Et nous vous remercions tous ceux qui ont pu être patients pour rejoindre ce webinaire. Et je souhaiterais passer la parole à Monsieur le Président du CPTA pour diriger les travaux de ce webinaire. Et on remercie tous les panélistes et tous ceux qui ont contribué à ce que ce webinaire puisse se tenir. Je vous remercie.
C'est nous qui vous remercions, cher Bruno, pour le travail abattu pour préparer ce webinaire sur tous les plans. Donc, soyez-en remerciés. Alors, de prime abord, je voudrais d'abord souhaiter la bienvenue à tous les participants à notre webinaire. C'est un webinaire qui va être convivial cette année parce que nous allons travailler avec des amis que nous connaissons bien, donc des membres du CPTA, mais des experts qui nous sont très proches. C'est une innovation que nous faisons cette année. Les années précédentes ont célébré cette journée contre la torture, qui est une journée des Nations Unies. Donc, le monde entier l'a commémoré en rendait public une belle déclaration. Mais on s'est dit que cette année, avec l'expérience du CPTA, les experts que nous avons, il fallait rehausser cette journée et faire un bon panel où nous profiterons des connaissances et des expériences des uns et des autres. Alors, malheureusement, aujourd'hui, nous allons être privés de la présence de notre vice-présidente, Mme Maya Salifadel, qui est en déplacement vers Dakar. Elle ne peut pas se connecter. Si elle était même dans un aéroport, je sais qu'elle serait connectée. Alors, le programme de notre réunion, donc, normalement, Mme Maya devait lire la déclaration, la rendre publique. Je vais le faire à sa place. C'est un plaisir. Ensuite, donc, je donnerai la parole à notre amie Mme Onaïma, qui va présenter les différents panélistes. Alors, les intervenants seront dans l'ordre que je vais dire à présent, selon l'ordre du jour que j'ai. Donc, c'est d'abord Mme Sanem Ousbih, qui nous parlera du cadre juridique pour la torture. Ensuite, nous aurons une intervention de Mme Evanoud, notre conseiller juridique qui a dignité. Bon, on fera la présentation, Mme Onaïma le fera, donc il parlera de l'impact de la torture sur les réfugiés et les personnes déplacées. Et la troisième intervention sera faite par Mme Betty Odalo, conseillère technique principale, donc, qui interviendra sur l'impact de la torture sur les femmes et les filles, un sujet très brûlant également. Ensuite, le professeur Serge Boumeni va modérer les discussions et les questions-réponses, et après, donc, on clôturera notre panel. Alors, sans plus tarder, pour ne pas perdre de temps, je vais donc, je ne sais pas si la déclaration, vous l'avez certainement eu peut-être avec les documents, sinon, on va vous l'envoyer. Donc, voilà la déclaration du CPTA à l'occasion de la Journée internationale pour le soutien aux victimes de la torture. La Commission africaine des droits de l'homme et des peuples, à travers son comité pour la prévention de la torture en Afrique, le CPTA, se joint à la communauté internationale pour marquer le 26 juin, Journée internationale pour le soutien aux victimes de la torture. La présente commémoration revêt un intérêt particulier pour le CPTA, qui a choisi comme thème de son action en 2022 la réparation des victimes de la torture. En effet, les conséquences des actes de torture sont multiples et dévastatrices. Ainsi, de nombreuses victimes n'accèdent pas aux mécanismes globaux de réparation mis en place par les parties prenantes aux fins de traiter les répercussions des violations de droits humains. Aussi est-il primordial pour le CPTA de comprendre le processus et les effets des actes de torture sur ces victimes afin de mettre en place un ensemble de stratégies et programmes destinés spécifiquement à leur apporter la réparation particulière dont elles ont besoin pour approcher un retour à la situation cohantée. Le CPTA insiste sur la nécessité primordiale de réparation pour les victimes des actes de torture chaque fois qu'il est saisi de cas types. Le CPTA a aussi inclus la question de la réparation dans son processus de formulation de règles portant création et fonctionnement du mécanisme d'alerte et de rapport à la Commission africaine des droits de l'homme et des peuples des situations de torture. En effet, en requérant que les conséquences des actes de torture soient décrites sur le formulaire de saisine CPTA, Ce dernier anticipe les mesures de réparation appropriées à obtenir de l'État et toute autre partie prenante au profit de la victime, en ce que la réparation est un droit pour celle-ci. La journée internationale pour le soutien aux victimes de la torture et la date d'anniversaire de l'entrée en vigueur de la Convention contre la torture et autres peines ou traitements cruels, inhumains ou dégradants, le 26 juin. La Convention étant le principal instrument juridique international qui oriente et encadre les législations nationales et l'action des organisations internationales et sous-régionales en matière d'interdiction de la torture et de lutte contre ses conséquences dévastatrices sur les victimes, il est capital de faire un plaidoyer afin de parachever la ratification continentale de cet important instrument au-delà des 52 États africains qui sont partis à ce dernier à ce jour. Le CPTA marque cette journée par l'organisation d'un webinaire afin de révéler et discuter l'impact des actes de torture sur des catégories vulnérables spécifiques que sont les déplacés internes, les filles et les femmes. Cela va permettre de mesurer l'ampleur des effets des actes de torture sur ces personnes et formuler sans nul doute les mesures réparatrices adéquates à leur endroit. Il va s'agir aussi de rappeler tout le dispositif préventif afin d'éviter à tout prix la survenance de la torture tel qu'il est un crime absolument interdit en droit international. Ainsi, l'article 5 de la Charte africaine des droits de l'homme et des peuples qui encadre cette interdiction absolue de la torture au plan continental africain doit être au cœur de toutes les actions étatiques en toutes circonstances afin d'éviter d'invoquer quelque situation spécifique que ce soit pour y déroger, comme il en est malheureusement le cas avec la pandémie Covid, la lutte antiterroriste et autres circonstances où les parties prenantes échouent à maintenir le caractère de jusqu'audience dont est revêtue l'interdiction absolue de la torture. Il est enfin important d'être optimiste en s'appuyant sur le maintien et non la remise en cause par des États et les parties prenantes du caractère absolu de l'interdiction de la torture et de l'obligation de réparation telle qu'établie par la pratique internationale et les dispositifs juridiques solides mis en place à cette fin. Il s'agit de continuer d'œuvrer à l'application stricte et systématique de ce dispositif en plaçant au cœur de toutes les actions la nécessité de rétablir autant que possible les victimes dans leur situation d'avant la survenance des actes de torture à leur détriment, sinon, pourquoi pas, dans des situations meilleures. Je vous remercie, mesdames et messieurs, de votre attention. C'était là la déclaration donc, du CPTA pour la journée de la torture. Donc, sans plus tarder, nous allons donc entamer notre panel, notre webinaire. Alors, je vais céder la parole à madame Oneima, qui va avoir l'obligeance donc de nous présenter nos trois intervenants, en commençant par madame Sener, ensuite madame Eva et madame Betty, et après donc madame Sener fera son intervention. Madame Oneima, please, you have the floor.
Thank you very much, Commissioner Hatem. It's indeed my pleasure and honor to introduce our three panelists today. Ms. Sana Busby is an expert member of the CPTA, not a stranger to us. She is a human rights and a humanitarian law expert, and has been working tirelessly in the region, addressing issues that have been affecting IDPs and refugees and those affected in one way or the other by conflict. Ms. Eva Nerd is a legal advisor at Dignity, but also a very dear partner of the CPTA, and has been working closely, doing research and supporting the Special Rapporteur on the rights of IDPs, refugees, and migrants in Africa. And her presentation will be highlighting some of the vulnerabilities that affect those who have been displaced or are refugees in other countries. And it's my pleasure to also introduce our third and final panelists, Ms. Betty Odalo. Betty is a senior technical advisor at the Center for Reproductive Rights. She is also a human rights and humanitarian law expert and has worked quite closely on these issues within the continent, including with the African Children's Rights Committee. And she will be highlighting vulnerabilities that impact women and adolescents and children in particular. So initially, each panelist was told that they would have about 15 minutes to present, but we do know that due to technical issues, we are starting quite late. So please feel welcome to cut down on the presentation, and that will allow us to still end at the previously scheduled time. So I will hand this over to Ms. Sana, who will be laying the groundwork, highlighting the legal framework with what promises to be an interactive session. Thank you.
Merci beaucoup, Onyema. Donc, je fais un énième test de micro pour être sûr que tout le monde m'entend correctement. Oui, très bien, merci. Alors, si vous le permettez, par contre, moi, j'ai un petit problème d'Internet parce que j'ai un petit peu raté l'allocution de départ. Si vous me permettez, je vais juste éteindre la caméra juste pour que ce soit plus fluide au niveau des échanges, mais je vous vois très bien. Merci beaucoup. Bienvenue à tous nos amis qui viennent de nous rejoindre également. Bon dia, Zaida. Alors, lorsque l'opportunité de venir parler s'est présentée et durant toute la semaine passée, je me suis un petit peu interrogée sur quel angle est-ce qu'on devait aborder la situation de torture au regard des dispositions des lois internationales, de la Convention, de l'UNCAT, et puis également des mécanismes régionaux. Puisqu'il s'agit aujourd'hui de parler également d'obligations de la part des États envers les personnes qui sont touchées par la torture, j'ai choisi peut-être de rappeler légèrement les trois grands types d'obligations pour les États. Donc, d'une manière générale, la pierre angulaire, je dirais, des droits humains se distingue par trois types. Donc, l'obligation de respecter, l'obligation de protéger et l'obligation de garantir et de donner effet. Donc, ces trois grandes obligations sont inhérentes aux mécanismes actuels en matière de droits de l'homme. Je vais peut-être faire un léger rappel de ce qu'incombe l'obligation de respecter, qui est la première des obligations d'un État vis-à-vis du respect du droit humain ou des droits humains. Par respect, qu'est-ce que l'on entend? On entend l'obligation pour l'État de s'abstenir d'interférer de manière injustifiée dans les droits humains garantis des individus. Ça signifie pour l'individu qu'il peut se défendre contre les ingérences dans ses droits commises par l'État. C'est une espèce de droit de défense ou d'obligation de respecter qui s'y rapporte. Donc, on l'applique en règle générale pas de manière absolue, hein, parce qu'il y a quand même, si Hatem lors de l'introduction, évoqué aussi les limites justement inhérentes aux situations actuelles, notamment celles liées à la sécurité, celles liées également à l'hygiène et à la santé, n'est-ce pas? Mais donc, ce sont ce qu'on appelle des raisons légitimes à une restriction des droits humains par l'État. D'accord. Donc là, on était sur l'obligation de respecter, qui est vraiment la première grande règle à respecter au niveau des États et la première obligation. Ensuite, on a cité l'obligation de protéger. Donc, hein, c'est une obligation pour l'État de protéger les droits humains des individus contre les abus qui peuvent être perpétrés par des tiers ou par même l'État d'une manière générale ou par des organes de l'État qui sont un petit peu incontrôlables. Donc, c'est soit des personnes privées, par exemple, ou des acteurs non étatiques. Et on a également parfois des entreprises dans certains pays qui perpétuent certains actes répréhensibles qui mettent en danger la liberté des individus. L'obligation de protéger est de nature soit préventive, soit réparatrice, par essence. Donc, l'État est obligé de prendre des précautions qui sont nécessaires pour prévenir un risque avéré d'atteinte aux droits humains par un tiers. Et si un État devait être finalement violé, si un droit, devait être finalement violé, l'État doit veiller à ce qu'une réparation soit obtenue. Donc là, on est encore sur les bases claires de types d'obligations en matière de droits humains. Et enfin, l'obligation de donner effet ou de mettre en œuvre, c'est le troisième niveau, je dirais, d'obligation de l'État qui consiste à garantir que les droits humains d'un individu puissent être effectifs en pratique. Et ça, c'est très intéressant pour nous à ce niveau-là. Ça signifie que l'État est obligé de créer des conditions nécessaires pour la jouissance réelle d'une garantie de droits humains, la jouissance du droit en soi. Donc, l'État doit prendre des mesures pour établir des bases légales, institutionnelles ou procédurales pour une réalisation complète du droit en question. Alors, c'est un comportement actif de l'État qui est donc attendu dans ce troisième cas. L'État doit par exemple mettre au point une législation qui prévoit un système de protection, un système de recours et un système de réparation en cas de torture. Dans notre cas, sans lequel le droit à saisir d'une plainte n'aurait absolument aucun sens, si on voit ça de cette façon-là. Donc, ça, c'était pour essayer de mettre un nom sur ce qu'il y a derrière la constitution de conventions et de mécanismes et d'instruments qui régulent les droits humains, les droits humanitaires également. Je pense que Eva en parlera peut-être tout à l'heure. Mais surtout, en ce qui nous concerne, au niveau de l'interdiction de la torture. Justement, l'interdiction de la torture et des peines ou traitements cruels, inhumains ou dégradants est une interdiction qui est omniprésente dans plusieurs instruments internationaux et régionaux qui constituent les droits de l'homme et également le droit humanitaire. En revanche, la Convention des Nations Unies contre la torture et d'autres peines et traitements inhumains et dégradants est la seule convention qui est juridiquement contraignante au niveau international qui concerne exclusivement l'élimination de la torture. Alors là, qu'est-ce qu'on apprend à ce niveau-là? C'est que ça, c'est au niveau global. L'objectif principal de la Convention, c'est surtout d'imposer aux États parties l'obligation d'établir et d'exercer surtout leurs compétences à l'égard du crime de torture. Et la Convention impose en outre aux États d'importantes obligations de prendre des mesures pour prévenir la torture et faciliter la réparation des victimes et les survivants de la torture. Il y a une obligation également que je n'ai pas citée, mais qui est celle également en outre de protéger, c'est également d'établir un dispositif qui permet également de punir les actes qui ont été commis. Les implications juridiques des dispositions de la Convention ne sont pas nécessairement bien connues, honnêtement, en dehors des cercles des organisations non gouvernementales spécialisées et dans les universités. Donc, on s'y réfère dans le journalisme mainstream à simplement un acte commis, une défense lorsque c'est applicable et un positionnement de l'État. Mais nous savons très bien que tout cela n'est possible qu'à travers également la mise en place de tout un système juridique en fait, et législatif et légal afin de permettre ces trois grands axes en fait, de s'accomplir et également que tout ce qui est de l'ordre de la prévention et de la réparation puisse avoir lieu. En ce qui concerne le contenu légal national, les dispositions essentielles concernent l'exécution pénale surtout. Celle-ci exige des États parties qu'ils veillent à ce que la torture, la tentative de torture et la complicité de torture soient des infractions au regard de leur droit pénal et qu'ils rendent ces infractions passibles de peines appropriées qui tiennent compte de leur gravité. Alors là, je me lis moi-même en réalité, puisque en préparant cette intervention, il en ressort également une obligation intrinsèque, qui est celle de mettre en place un mécanisme légal et juridique qui permette d'appliquer non seulement la jouissance du droit d'un côté, mais également la protection contre l'intervention malveillante d'un tiers. Les États, en ce sens, doivent prescrire des lois pour punir des actes commis sur leur territoire, ainsi que par leurs ressortissants, même en dehors de ce territoire, et le cas échéant, contre leurs ressortissants et dans toute autre situation où ils choisissent d'intervenir. Les États doivent également détenir tous les tortionnaires présumés sur leur territoire, quel que soit leur lieu d'infraction, et les soumettre aux autorités de poursuite, soit les extrader. Donc là, on est dans d'autres dispositions des conventions, de la Convention contre la torture, mais également dans d'autres dispositions, d'autres instruments régionaux, et qui obligent les États à collaborer justement en matière de protection d'une part, en matière de prévention, mais également en matière donc de répression des actes de torture commis par des tiers. Enfin, les États sont tenus de prévenir la torture par divers moyens et de donner aux victimes le droit de porter plainte, justement, contre la torture. Alors, est-ce que pour l'instant, il y a des questions sur ces parties-là? Peut-être, Onyema, tu souhaitais intervenir, parce que là, avant même de rentrer dans ce que dit le UNCAT et dans ce que disent les lignes directrices de Robben Island, peut-être qu'il est utile de faire une pause ici et de s'interroger justement sur ce que la question de l'obligation entraîne et de la contrainte en soi lorsqu'il s'agit du droit humain.
Non, pardon, Madame Saner, notre agenda, c'est qu'on fasse les 3 interventions d'1 quart d'heure chacune, et ensuite on ouvre le débat qui sera piloté par Monsieur Serge.
Très bien, super, merci beaucoup.
Terminez votre intervention.
Très bien, merci beaucoup. Pour rester sur le UNCAT, on a tous les articles sont extrêmement intéressants, mais l'article 16 l'est particulièrement pour nous aujourd'hui. Parce que l'article 16 oblige les États parties à empêcher les agents publics de commettre ou d'acquiescer d'autres actes de traitement cruel, inhumain et dégradant. Les États deviennent tenus de donner effet à ces dispositions à partir du 30e jour suivant la date à laquelle ils déposent auprès du secrétaire général de l'Organisation des Nations Unies leur volonté de signer le UNCAT. Une fois ratifiées, les normes nationales ne peuvent être invoquées pour justifier le non-respect des obligations en soi, mais ce qui est important dans cet article 16, c'est que à compter du moment où un pays décide de faire partie en fait, des pays ratifiés, adoptés le UNCAT, il y a une obligation de réaction qui doit s'imposer derrière. Alors, au niveau des réserves, du coup, de ce qu'il y a quand même une marge de manœuvre au niveau des États, au niveau de certaines réserves qui sont formulées par certains États lors de l'adoption de UNCAT. Donc, il est possible de formuler véritablement ces réserves à l'égard de certains articles de la Convention au moment de la ratification ou de l'adhésion. Par contre, toutes ces réserves ne doivent pas être contradictoires vis-à-vis des buts et principes de la Convention en soi. Maintenant, et pour terminer sur cette partie uniquement, comment est-ce que l'on fait? Comment est-ce qu'un État fait pour mettre en œuvre ces traités internationaux, aussi bien le UNCAT que les lignes directrices, que la charte, que même au niveau de l'Amérique latine, de la Convention contre la torture de l'Amérique latine? Comment est-ce que ça se passe? En réalité, il n'existe pas de méthode standard. Il y a des manières préférées, mais il n'y a pas exactement de méthode standard. Tout simplement parce que chaque pays est différent vis-à-vis de l'état d'avancement des droits humains dans son pays, mais également au niveau de la composition même de son système de gouvernance ou de son système législatif. il y a certaines méthodes donc, du coup, que l'on préfère. Et puis, parmi celles-là, on a celles qui comprennent l'incorporation, l'adoption et la transformation de la législation interne selon les dispositions nouvelles et peut-être même de l'adoption par la Constitution de certains de ces principes-là. Il y a également celle qui dit que qui souhaite que l'effet du droit sur la compétence nationale, du droit international sur la compétence nationale, ne peut se faire que par l'adoption de ces principes, de ces grands principes au niveau constitutionnel, mais également par l'adoption assez rapide de certains mécanismes de pratique. Le tout étant que, aussi bien au niveau de la pratique, au niveau de la méthode et au niveau du contenu de ces législations ou de ces mécanismes internes nationaux, celle-ci n'érode pas le contenu de la convention du UNCAT. Voilà. Maintenant, qu'en est-il des lignes directrices de Robben Island? Très clairement, les lignes directrices ne sont pas un instrument à part, puisqu'elles ont été érigées à la lumière et grâce également à la corrélation qui existe entre les instruments juridiques internationaux que l'on vient de citer et également un besoin qui a été très largement perçu sur notre continent. Qu'est-ce qui se passe au niveau de nos lignes directrices? Donc, nous sommes ici, nous en connaissons la nature, mais qu'est-ce qui se passe en réalité au niveau, qu'est-ce qui est innovant au niveau des lignes directrices? Déjà, c'est un instrument régional qui mesure, c'est une mesure d'interdiction et de prévention de la torture et des peines ou traitements cruels, inhumains ou dégradants en Afrique, et qui sont le fruit d'une coopération intrinsèque parmi les mécanismes de la Commission et également non seulement des ONG, mais également au niveau de la recherche, au niveau du droit international. C'est le fruit de tout cela. Alors, on part d'un constat, c'est que nous sommes dans une région du monde qui est extrêmement dense et extrêmement peuplée, et également qui est en perpétuelle transition. Tout comme la Convention contre la torture, UNCAT qui comprend 3 grandes parties, les lignes directrices également contiennent 3 grandes parties qui rappellent non seulement l'obligation faite aux États africains de ratifier les instruments régionaux et internationaux pertinents relatifs aux droits de l'homme et contre la torture et autres peines ou traitements cruels, inhumains ou dégradants, qui rappelle la nécessité de la promotion et de la coopération avec les instruments internationaux, qui criminalise l'acte de torture ou les actes de torture, qui favorise et qui insiste sur la lutte contre l'impunité, qui insiste sur la mise en place de mécanismes et procédures de plainte et d'enquête. C'est un des éléments innovants également. Et sinon, en deuxième partie, elle se rapporte surtout à la prévention de la torture. Elle insiste sur le traitement à accorder aux personnes privées de liberté et au rôle de la société civile également là-dessus. Elle garantit les garanties fondamentales pour les personnes privées de liberté, les garanties durant la détention préventive, la détention, des détentions plus humaines, plus organisées, plus en phase avec le système évolutif et moins en phase avec les systèmes restrictifs ou d'atteinte à la personne. Elle met en place également, elle dicte la mise en œuvre d'un mécanisme, en fait, en français, ça donne mécanisme de surveillance, mais c'est plus un mécanisme de monitoring, justement, de la torture. Elle encourage la formation et le renforcement des capacités des personnes, bien entendu, également de la société civile. Et en dernière partie, grande partie, je dirais, les lignes directrices répondent aux besoins des victimes et recommandent les mesures de protection des victimes de torture, des témoins, des personnes à charge, des enquêtes, des défenseurs des droits de l'homme et de leur famille, la réparation également accordée aux victimes. Je voulais enchaîner également avec, la corrélation et le type de collaboration et les relations entre l'OPCAT et les lignes directrices de Robben Island. J'ai peur de manquer de temps là-dessus. Je vais quand même essayer de dire un mot. Les lignes directrices, elles ne sont pas juridiquement contraignantes, n'est-ce pas, mais reflètent dans une certaine mesure les normes internationales dans leurs dispositions, et les lignes directrices ont été conçues comme un outil justement pour leur mise en œuvre. Donc, ces lignes directrices sont conçues également pour que le travail dans les États, que les États soient aidés à la mise en œuvre justement par exemple de la Convention contre la torture. Alors, il y a diverses choses qui rapprochent l'OPCAT et les lignes directrices de Robben Island, bien que nous ne soyons pas là dans un cours de droit comparé, mais je dirais très rapidement que le concept de prévention qui est au cœur de l'OPCAT et des lignes directrices de Robben Island contiennent des dispositions détaillées sur la manière dont cela peut être mis en œuvre. Les lignes directrices de Robben Island sont beaucoup plus détaillées là-dessus. Alors que le paragraphe, par exemple, du préambule de l'OPCAT rend référence à la prévention comme qui inclut l'éducation, la législation, l'administration, la justice et autres mesures. Dans la pratique, les gouvernements et les mécanismes nationaux, si on s'en réfère à l'OPCAT, ne savent véritablement pas quelle est la méthodologie pour la mise en œuvre. Donc, ce qui n'est pas le cas avec les lignes directrices qui, compte tenu de l'étendue de son mandat, donne des indications sur ce que l'on entend par exemple, lieu de privation, monitoring et protection, réparation, etc., etc. Donc, je vais peut-être m'arrêter là parce que je pense que je vais digresser et aller peut-être dans quelque chose qui ne concerne pas tout de suite, ou peut-être nous n'avons pas le temps aujourd'hui de discuter de cela. Mais voilà, j'ai essayé de poser de manière peut-être un petit peu évasive certaines règles essentielles d'obligation pour les États. Je les rappelle d'ailleurs, les obligations de respecter, les obligations de protéger, l'obligation de donner effet et de mettre en œuvre que nous retrouvons dans les lignes directrices de Robben Island, n'est-ce pas, et qui sont même décrites de manière assez détaillée comme étant véritablement un instrument de mise en œuvre et un instrument également de protection et de prévention contre la torture. Je m'arrête là. J'espère que ce n'était pas trop long et que cela a apporté quelques peut-être pistes de réflexion sur d'éventuelles recherches ou d'éventuelles corrélations. Donc, j'aurais pu continuer très, très longtemps avec des mécanismes européens, les mécanismes d'Amérique latine. Il m'a été un petit peu compliqué de passer, de restreindre cela à seulement 15 minutes. Mais j'espère que le contenu, vous a permis d'ouvrir peut-être quelques voies de réflexion. Merci beaucoup. Over to you, Onyema.
Thank you very much. Thank you very much, Ms. Sana. I'll pass this on to Ms. Ever without any delay. And do remember, if it's possible to, I know that you have prepared quite a bit. If it's possible to make it a bit shorter than you intended, we would appreciate that as well. Thank you.
Thank you, Onyema. Good afternoon, everyone, the Honorable Commissioner Hatem, the panelists, and distinguished guests. And thank you, Sana, for the thorough presentation on the torture framework, both at the international and regional level. I was invited today to present on the issue of torture of refugees, internally displaced persons, and migrants in Africa. This is a topic that has been in the news for several years, and I'm sure the horrific stories and images haunt many of us, and we wonder what we can do to help them. My presentation, therefore, will focus on the legal remedies for the victim and state obligations to prevent tortures of migrants and refugees and IDPs. I will commence with the legal definition of migrants and refugees, followed by the introduction of the context of migration in Africa, explaining the violations that the migrants and asylum seekers endure, then discuss the state's obligations regarding torture, and finish with some practical things we, lawyers and civil society, can do on the issue of torture and migrations. Under the international law, specifically under the 1951 Refugee Convention, term refugee is defined as a person unable or unwilling to return to his or her country of nationality due to a well-founded fear for being persecuted for reasons of race, religion, nationality, and membership of a particular group. Unfortunately, there is no similar definition of migrants under the international law. The Office of the High Commissioner for Human Rights has introduced the term international migrant only in 2014, stating that international migrants definition encompasses all persons outside of the state of which they are citizens or nationals, or in case of stateless person, their state of birth or habitual residence who are not refugees. During this presentation, I will be speaking about migrants, asylum seeker, and internally displaced persons. I will be referring to the term migrants interchangeably with refugees and asylum seekers. Even though asylum seekers and migrants have different legal statuses and corresponding rights, most of them undertake the same perilous journey just to reach safety destination and are exposed to the same severe human rights violations, including torture, enforced disappearances, rape, and sexual violence, and arbitrary detention, among others. Before I will discuss the horrific experience and violations migrants endure, let me speak about the history and reasons for migrations or asylum seeking on the continent. Phenomena of migration is nothing new to Africa. It dates back centuries and includes practices such as slave trade, trade of commodities and labor, and trading routes between East Africa and Middle East. In 1900s, large number of people, predominantly from Asia, came to the continent to work on sugar farms and build infrastructures, including railways. In the last decade, migration on the continent has increased significantly. According to the African Union report on migration from 2020, in a period of 2008 to 2017, number of migrants on the continent went from 13.3 million to 25.4 million people, almost doubling in one decade. The 2020 UN report on the assistance to refugees, returnees, and displaced persons in Africa provides even more striking statistics, noting there are 33.4 million forcibly displaced persons, including 6.3 million refugees, 600,000 asylum seekers, and 18.5 million internally displaced persons on the continent alone. Many of these people are girls and women, with latest statistics showing that nearly half of the migrants are women and girls. In 2019, the International Office of Migration's report showed that 47.5% of migrants from sub-Saharan Africa were women and girls. There are a lot of push and pull factors that contribute to migrants and asylum seekers leaving their home country. While perception is that most migrants seek refuge in Europe, the statistics show that most remain on the continent and migrate into a different African country. Some leave due to civil war and strife, famine, lack of effective rule of law, political instability, human rights violations, security concern, or in most recent years due to environmental degradation. Many also choose to leave due to high levels of poverty to seek better economic and educational opportunities and better life. In the last decade, the migration on the continent almost doubled in numbers, but also the treatment of the migrants and asylum seekers have become much worse due to several factors. First, many states have adopted laws that criminalize irregular migration, forcing many asylum seekers and migrants to use less safe routes and rely on criminal gangs and trafficking gangs, which exposes them to serious human rights violations such as torture, enforced disappearances, rape, and sexual violence. Libya, one of the top transit destination countries for many migrants who are seeking better lives in Europe, adopted a law in 2010 that criminalizes illegal entry and exit from Libya and provides that foreign illegal immigrants shall be penalized either by detention with hard labor or by fine. Niger, another transit country to reach North African countries, adopted similar law criminalizing smuggling in 2015. While the law aims to punish smugglers and provide for the protection for the migrants deprived of their liberty to be informed of their right to communicate with consular services of their country, the reality is very different, forcing many migrants to live in hiding and undertaking dangerous routes to avoid being detected. The second factor is the perception of migrants and asylum seekers and securitization of the borders. Many governments have portrayed immigrants and asylum seekers as security concern, describing them as people who bring violence to the country and increase crime, as well as to carry out terrorist activities. Many countries, as a result, have adopted measures that led to securitization of the borders, providing opportunities for increased abuses, carried out both by state security forces and non-state actors. The securitization of border control is a prominent feature of the EU's Borders Externalization Project that requires governments to control detained migrants before they reach the shores of Europe, resulting in many states deploying military techniques such as patrol vehicles, drones, and other surveillance to detect migrants and detain them. These are just two main factors that have contributed to creation of a climate of fear among migrants and asylum seekers, leading to many seeking unsafe routes to avoid being detected and detained. However, this approach unfortunately exposes many of them to ill treatment, sexual violence, and other violations on the move along the migratory routes at the various checkpoints manned either by state security or non-state actors and at various border crossing and detention facilities. So let me just quickly discuss the violations that the migrants are exposed to. Migrants and asylum seekers report abuses at all stages of their country, inside the country they're leaving, along roads of the migration routes, at official and unofficial checkpoints, at the border control, and within the detention facilities. Many speak of violations of their basic fundamental human rights, such as freedom from torture and other inhuman, degrading treatment and punishment, being raped or sexually violated, experiencing regular beating, being forced to share cells with too many people, and being forced to carry out hard labor, and being detained in arbitrary detentions for indefinite periods. While torture and ill treatment can occur anywhere, in the context of migration, detention facilities ran by state and non-state actors have been repeatedly singled out as places where migrants are subjected to inhuman conditions and torture, including severe beatings, hard labor, threats of killing, applications of electric shocks, and extortion of payment for freedom. Further, detention facilities are often overcrowded, with people taking turns to sleep. They have limited access to medical care or washrooms. They are provided with little or no food and sanitation, and women and girls are in danger for rape and sexual violence and threat of sexual violence. I will quickly discuss a report from Libya because I think it highlights what's really happening on the continent. Libya is one of the main transit countries and is notorious for holding migrants in detention facilities and depriving them of their basic rights. The 2020 United Nations Office for High Commissioner for Human Rights released a report summarizing the experience of migrants and the violations they endure in Libya. While Libya is a party to several international treaties that protect the rights of migrants, the report notes that there is very little respect for human rights. In recent years, many have been subjected to forced expulsion, and the rise of false expulsions also means that many migrants and asylum seekers don't have access to proper legal assistance and procedural safeguards to assess their status in the country and argue against expulsion. Because illegal entry in Libya is criminalized, many migrants spend months and sometimes years in arbitrary detention centers run by state and non-state actors, exposing them to various human rights violations. And given that Libya is a failed state with various territories of Libya being governed by militias and non-state actors supported by the government, many migrants and asylum seekers do not have access to justice for their violations and remain at the mercy of traffickers and gangs who extort them before they are released. Example of Libya and treatment the migrants endure in this country is, however, not unique to the country, but rather sadly common practice among many African countries. I will now quickly address a few things that Sana already had said in regards to torture, but I think it's important to kind of remind us that prohibition of torture has attained a jus cogens norm in the international law, thus ensuring torture is never permissible, and this principle applies to migrants as well. Therefore, the fundamental rights of all migrants, including the right to be free from torture and other treatment, must be respected, protected, and fulfilled throughout their entire journey while traveling from country of origin, transit, and destination, irrespective of their legal status. The International Convention Against Torture and Other Cruel, Inhuman, and Degrading Treatment and Punishment has currently 173 state parties. On the African continent, only 2 countries, Zimbabwe and Tanzania, have not signed the convention. Closer to the home, there are several instruments that prohibit torture. The African Charter on People and Human Rights, to which only 1 African state is not a party to, through Article 5 notes that every individual has a right to respect of dignity and prohibit torture, cruel, inhumane, or degrading treatment and punishment. And then also the Robin guidelines that were already previously mentioned by Sana. And finally, in 2017, the African Commission adopted a General Comment number 4 on the right to redress for victims of torture and other cruel, inhuman, and degrading punishment or treatment to strengthen the provision of the rights of victims to torture to reparations. Finally, the African Commission has specifically dedicated Office of the Special Rapporteur on Refugees, Asylum Seekers, Displaced Persons, and Migrants in Africa, whose mandate since 2006 has been to include migrants with focus on monitoring of human rights violations, undertaking studies and fact-finding missions, and assisting member states in developing appropriate policies, regulations, and law for the effective protection of migrants, asylum seekers, and IDPs. It is clear that both international and regional treaties outline specific state obligations to prevent, protect, investigate, prosecute, and provide reparations to the victims. I will discuss a few of these, particularly how they relate to the migrations. Duty to prevent includes the adoption of effective legislative, administrative, and judicial measures to prevent torture. They also include amendments or repeal of discriminatory laws and policies that put migrants in situations of vulnerability. In addition to the legislation, states are required to take effective measures to prevent public officials and other persons acting in an official capacity from directly committing, instigating, inciting, acquiescing, or participating or being somehow complicit in acts of torture in all the stages of migration proceedings, including borders and the detention facilities and upon return to their home country. This requires that states provide the officers engaged in these proceedings with effective human rights training, as well as regular review of interrogation techniques and detention policies and investigations and prosecutions of perpetrators. States also should adopt laws to regulate migration and asylum procedures to ensure migrants have access to proper procedures to evaluate their status. The states have also obligations to respect the principle of non-refoulement that forbids countries to return asylum seekers to a place where they would be in likely danger of persecution or being tortured. This obligation is particularly enshrined in Article 13 of the Untitled Charter that prohibits the mass expulsion of non-nationals, as well as the General Comment number 4, which urges states to ensure compliance with the prohibition of non-refoulement and many international treaties, including the 1951 Refugee Convention. As most abuses reported by the victims occur within detention facilities, the states should adopt policies to prevent abuses in these facilities by not criminalizing illegal migration, ensuring that if the detention occurs, migrants are not detained in poor conditions for indefinite periods, and that they should have access to legal and medical services. I will now speak a little bit about the opportunities for the victims to access redress, which I think is incredibly important because the migrants transient through several countries. So I will discuss the obligations of the states in that regard. States also have the obligations to provide redress to the victims of torture. Article 14 of the Convention urges states to provide remedies for the victims of tortures that occurred on the territory of the state under their jurisdiction and including international borders. The state should provide victims with fair and adequate compensation, access to means for a full rehabilitation. They should identify migrants as early as possible who are survivors of torture by using the Manual on Effective Investigation and Documentation of Torture and Other Cruel, Inhuman, and Degrading Treatment and Punishment, or Istanbul Protocol, as it's more commonly known, and then ensure that these victims have access to effective and immediate medical services and legal assistance to report their cases of torture in the country where torture occurred. To avoid further violations, states are encouraged to provide trainings to police, border agents, and other relevant parties on human rights law. States should also set up systems to make it easier for migrants to report the violation and obtain access to justice without fearing they will be arrested and deported as a result of their migration status. So I will finish with kind of a couple of things that we can do to work on prevention of tortures. It's clear that the obligations of the state in preventing torture and providing redress are enshrined in the international law. However, the reality is often different. Many of the states from which migrants and asylum seekers flee have weak rule of law, lack of accountability. The police lacks technical skills and resources to address torture. There is a high level of corruption. And finally, the migration is an incredibly lucrative business that many people would benefit from. So what can we do to help migrants, asylum seekers, and IDPs? One is to ensure the compliance with the laws. The civil society can work with the governments to ensure the law is effectively implemented and assist the government with training on human rights, international law, and international humanitarian law. Two, states should work together to set up DNA databases and collaborate together on investigations given the transient nature of migration. Number three is civil society and national human rights institutes that have mandates to receive and investigate human rights complaints and have access to detention facilities should collect evidence of torture and other violations while using that evidence to file public interest litigation cases on behalf of the victims seeking justice for the violations they endure. Number four is to write shadow reports to various international and regional bodies with mandates to address torture and demand international pressure on the governments to end torture and provide reparations to victims. And finally, since this is a seminar organized by the African Commission, report cases of torture to the African Commission and specifically the CPTA. Thank you for your attention, and I look forward to Q&A session after the presentation.
Thank you so much, Eva. I will pass this on to Betsy.
Thank you, Anyama. I believe everybody can hear me okay. All right, thank you. So good morning, good afternoon, everyone in the different places that you may be joining in from. I want to start, first of all, by saying thank you so much to the Commission, to the CPTA for the opportunity to speak to you on this significant day when we are continuing to unite, obviously, to speak against torture and to honor and support the victims and survivors of torture while continuing to uplift more and more their humanity and their dignity. And thank you so much, Sana and Eva, for your submissions, which are setting out the legal frameworks that are applicable to today's subject matter. In line with the mandate of the Center for Reproductive Rights, where I work, I'm going to speak about the reproductive rights of women and girls, as well as the reproductive rights violations of women against women and girls that amount to or that rise to the level of torture, cruel, inhuman, or degrading treatment. But let me first start by saying that from the outset, how we understand inequality in reproductive health is that it sets a basis and it requires access to reproductive healthcare services and access to reproductive healthcare information to be provided, one, without discrimination, to be affordable, to be available, and to be of good quality. And so when we speak about services and information, we mean services and information on maternal health care, on access to contraception, on safe abortion, etc., and accessing them in a way that is non-discriminatory, in a way that ensures that these services and information on these services are available, they're affordable, and they're of good quality. And so flowing from this, and also just flowing from, the definitions of torture, cruel, inhuman, and degrading treatment violations of reproductive rights amount to torture when they are manifestations of systematic discrimination against women, when they are manifestations of discrimination based on gender inequalities, and are for these reasons inflicted by or at the instigation of, or with the consent or the acquiescence of a public official or other persons who are acting in official capacity, and then they cause severe pain or suffering, whether the severe pain or suffering that is caused is, physical or mental. And then violations of reproductive rights amount to cruel, inhuman treatment when they cause severe pain or suffering, but fall short of that definition of torture that I just provided. And then they amount to degrading treatment when they are, extremely undignified, when they're aimed at humiliating a victim or a survivor, regardless of whether, there's severe pain or suffering that has been inflicted. And so when you look at those three, then you see very clearly how, violations of reproductive rights then intersect or rise to that level of torture, cruel, inhuman, and degrading treatment. And so I would just like to share a few examples with us of reproductive rights violations that rise to this level in three contexts: in the context of maternal health, in the context of access to contraception, and also in the context of access to abortion and post-abortion care. So to begin with, context around maternal health, the Center for Reproductive Rights and our partners have for a long time documented abuse and mistreatment of women and girls who are seeking maternal health services in ways that really cause tremendous and lasting physical and emotional suffering, and which are inflicted on the basis of gender. And so in 2007, the Center for Reproductive Rights and the Federation of Women Lawyers in Kenya published a report known as Failure to Deliver, where we documented widespread and systematic reproductive rights violations. We documented physical and verbal abuse when seeking maternal health care services, experiencing extended delays during labor, being stitched after birth without anesthesia, etc. And then we documented also the detention of women who had delivered together with their babies in healthcare facilities due to inability to pay hospital bills. I mean, of course, infringing upon their physical and psychological integrity, and arguably violating this right to be protected from torture, cruel, inhuman, and degrading treatment. Now, that was 15 years ago, but in a report that we undertook research for and launched last year in 2021 with one of our partners known as the Trust for Indigenous Culture and Health, we still came across cases similar to what we had found 15 years ago. So we documented young women who had suffered physical and verbal abuse in the context of seeking maternal health care services. And there was a judgment by the High Court of Kenya in a case that was brought by the Center and the Federation of Women Lawyers to challenge this post-delivery detention of women and their children for inability to pay hospital bills, in which Kenya was directed to put in place measures, including a waiver system for persons who are unable to pay their hospital bills. But despite this judgment, and despite there being additional commitments that we obtained by way of advocacy from the Ministry of Health, the practice still continues. And so the abuse of women, the detention of women is still widespread in both public and private health facilities, and sometimes with women and children being detained for longer periods, including more than a year, 2 years. We've documented these. This, of course, is an issue that the Center for Reproductive Rights and our partners have engaged the UN Committee on. and the UN CAT committee has expressed specific concern about this with regard to Kenya. It has expressed concern also on this subject with regard to the DRC, where we have documented and we have highlighted situations where women have been detained for inability to pay bills as small as $8. And in Nigeria also, where our partners who are based in Nigeria have worked with us to challenge the detention of a woman who was denied emergency services during the period when she was being detained, and actually, unfortunately, passed away as a result of the same. And so we still continue to highlight these situations of detentions, and we still continue to challenge them. But the problem is that they're still continuing to take place. The other thing that we highlight in the context of maternal health is placing, or the continued placing, of women at risk of preventable maternal mortality by not providing quality services that would assist them. And we say that this may amount to torture because maternal health services are reproductive health services, which are only required by pregnant persons, mostly women and girls. And maternal mortality in and of itself is both a form and a cause of severe pain and suffering to women who suffer it. As well as the families, obviously, that they leave behind. And on this specifically, we highlight Nigeria, which statistically has an incredibly high rate of maternal mortality. The country has one of the highest maternal mortality ratios in the world. There are approximately 158 women dying each day, but we still do not see Nigeria intervening sufficiently to address this issue. And then we still continue to highlight as well, in the context of pregnancy, maternal health care, continued invasive, mandatory forced pregnancy testing and expulsion of pregnant girls from school in Tanzania. And, with the change of regime, we all had thought that, there was indication that this might stop, but, our partners, including Human Rights Watch in Tanzania, are documenting, as recently as last year, continued forced pregnancy testing under circumstances that are putting girls in extreme stress, in extreme anxiety, and, are being basically made a precondition for girls to continue school or to enter school. Obviously discriminatory because it's only targeting these adolescent girls, and we are getting information that it's still encouraged by government officials and therefore continues to still be done in schools, as frequently, even in some cases, as once a month. And so I began by saying that discrimination against women and girls often underlies their torture and ill treatment. I've highlighted some of the situations regarding maternal health care in health settings. But apart from the examples that I've provided that cover maternal health, we do find that, there's particularly some truth to this statement when women are seeking treatment such as abortion and contraception, and post-abortion care as well, because these services are often seen as contravening socialized gender norms, socialized gender roles, socialized gender expectations. For example, that young women or women should become pregnant during their lives, they should give birth, and that they should be mothers. And so when they're seeking access to contraception or abortion care, then it seems to go against that. And so we find in law and practice that these gender roles and expectations are typically given primacy over the whole health and well-being of the woman. And I want to, just provide a few examples. So in the context of contraception, what we are documenting is continued denial of access to emergency contraception, especially for victims of rape and women and girls who live in conflict areas where rape is widespread, because such denials cause women severe mental suffering resulting from anxiety, especially about becoming pregnant. So for example, in the Democratic Republic of Congo, despite the fact that we all know that pregnancy due to rape is a palpable reality due to the high rates of sexual and gender-based violence, there's very low levels of awareness of emergency contraception, which the government is not addressing. And the levels of awareness when it comes to emergency contraception is what then would dictate proper uptake and proper usage of emergency contraception. But we see that because of the low rates of this, emergency contraception remains very underused, and usage is also affected by other factors such as stockouts, which have been documented across clinics in the country, with some clinics actually reporting having no emergency contraception at all in stock. And then outside of sexual violence and emergency contraception, we're documenting in Kenya and in Uganda, health service providers who are requiring third-party authorizations before granting access to contraception. So from adolescents, from young women, from older women as well, putting these women and girls in situations that truly compromise their autonomy and result in them not accessing services where they cannot obtain consent from the third parties that they're required to get consent from. And so many of these women face real mental anguish. They're scared, they live in fear and anxiety at the thought of getting pregnant because they cannot take care of children, because they're under circumstances where they would really love to prevent pregnancies, but they're unable to. And then last but not least, in the context of abortion and post-abortion, there are a few examples I really would like to highlight. We are documenting the existence of laws, for example, in Nigeria, that limit access to safe abortion through not permitting or through denying access to abortion in cases of rape, in cases of incest, and this is contrary to even what the Maputo Protocol provides. And so we find that this leaves women who are unable to, this leaves women who become pregnant from rape and incest in a state where they're consistently exposed to and reminded of the violations that have been committed against them. And of course, leaves them in situations where they're suffering from trauma and stress and risk really having these long-lasting psychological issues. And then we also document circumstances where there is a lack of clear guidelines for when to allow abortion. And what this does is that it leads to uncertainty amongst service providers and amongst women and girls on when they can access abortion services. A good example is Uganda, where there's constitutional provisions mandating Parliament to develop and adopt a law regulating access to abortion, but this has not been done yet. In Kenya, there's strong guidance on grounds for access to safe abortion in the Constitution, but there's continued application of penal law by law enforcement. And what this does is that it outlaws and outlaws the provision of abortion and puts medical providers and women and girls seeking services at real risk of being arrested, being investigated, charges being put against them. And this discourages the provision of safe abortion in line with the law. And so the center and our partner here in Kenya are actually working to address some of these circumstances, including in courts where we are challenging arrest and detentions of health service providers. We most recently challenged one where a patient was actually dragged from recovery in a hospital and was subjected to forced medical examination. And the health service provider who had provided services was also dragged from the facility and held in detention for a month as the law enforcement sought to establish whether an abortion had been conducted. And so we see these circumstances persisting, having a significant negative impact on emotional health and well-being of anybody who would want to seek abortion services. And then in Rwanda, as I move to almost completing, we've worked with our partners to document circumstances that still restrict access to safe abortion. We've worked with our partner, the Great Lakes Initiative for Health and Development, to institute litigation challenging the constitutionality of criteria that require abortion services in Rwanda to be provided only by doctors. Unfortunately, the Supreme Court did not agree with us and our partners and declined to find that these criteria that are restrictive are problematic. And so the court upheld them. But the implication is that we are barring trained mid-level healthcare providers, including nurses, midwives, who make up most of the country's healthcare professionals and are more accessible than doctors from providing access to safe abortion and leaving women and girls in a situation where they're unable to access. And when it comes to, the lack of access to services, limiting access to safe abortion services or denying access to safe abortion services, what should really strike us as well is the circumstances in which the women are left, because the circumstances in which the women are left include being forced to seek unsafe abortion. And these circumstances themselves can have severe and potentially permanent psychological impacts on women and girls. They also leave women and girls in situations where they are more vulnerable, ironically, to being denied post-abortion care, which also could seriously jeopardize their physical and mental health and could constitute in and of itself cruel and inhuman treatment. So, for example, in Kenya and in Nigeria, including for women who are affected by conflict, we have documented that women who are seeking post-abortion care are often subjected to delays of treatment, denials of treatment even. When they are provided services, sometimes they are faced with denials of pain medication. They are threatened sometimes to be reported to law enforcement for violating the criminal abortion laws. And so, as I conclude, I really would like to underscore once again that these violations that I'm highlighting are indeed underlined by discrimination. They do involve tremendous physical and psychological pain, and they do have devastating effects on women and girls. And I hope that contextualizing them today as a contravention of the right to be free from torture, cruel, inhuman, and degrading treatment really reinforces the urgent need to address them and challenge the impunity for those who would perpetrate them. And in terms of recommendations, I think since states are obliged to, prevent, punish, redress all forms of torture, cruel, inhuman, and degrading treatment, to begin by firmly recognizing and acknowledging reproductive rights violations and the fact that they can rise to the level of torture, cruel, inhuman, and degrading treatment, I think is a significant or would be a significant step forward in beginning to, fight for ending impunity for these reproductive rights violations. And I think it's critical for accountability mechanisms, including courts, including human rights bodies, as well as ourselves as advocates and other stakeholders, to ensure that frameworks that are intended to protect persons from torture, cruel, inhuman, and degrading treatment are applied in a manner that is gender inclusive and in a manner that is gender sensitive, because this would ensure that, the frameworks that are there to protect against torture, cruel, and inhuman and degrading treatment are also extending protection to women and girls. And then also that, governments would be held accountable to provide redress and to provide reparations for the severe pain, for anguish, for deaths that women and girls suffer as a result of a denial of their fundamental reproductive rights. Thank you very much, Anyama. I hope I didn't take too much time.
Thank you so much, Betty. And with that, we come to the conclusion of the panel presentations, and I'll hand this over to Professor Sesh to lead the discussion, keeping in mind
Merci de me donner la parole
time.
pour poursuivre la phase de discussion. J'aimerais d'emblée faire savoir aux différents participants que les questions se poseront de la manière suivante. Donc, à cette phase, chacun devrait se présenter pour une question et vous devez également désigner à quel intervenant s'adressera votre question. Et nous allons d'abord prendre une première série de trois questions, et après les réactions des différents intervenants, nous prendrons également une seconde série. Donc, je vais donner la parole à qui veut bien la prendre et soyez précis soyez précis pour permettre aux différents intervenants de répondre également avec précision et clarté aux différentes questions qui seront posées. Donc, vous voudrez bien, lorsque vous voulez poser votre question, lever la main et on prendra successivement. Alors, en attendant que les questions soient... Oui, je vois Madame Freitas qui lève la main. Je vous donne, vous pouvez poser votre question, Madame.
Bom, muito bom dia, não sei se me conseguem ouvir. Eu gostava de colocar uma questão, portanto, à última interveniente, à senhora, penso que Betty, de Quênia, que falou sobre a saúde sexual e reprodutiva, mas aqui mais com o foco nas questões da violência obstétrica, e aqui eu falo de práticas médicas abusivas, excessivas, para além do tratamento desumano, portanto, que provocam, para além enfim, que têm um impacto a nível psíquico, mas também, portanto, a nível físico, mas também a nível psicológico. Até que ponto podemos fazer este enquadramento e considerar atos de tortura e tratamento cruel? Portanto, aqui eu falo não só de práticas médicas, portanto, abusivas, portanto, durante o período de parto, mas também toda a forma como muitas mulheres são tratadas durante o momento do parto. Muito obrigada.
Je pense que cette question s'adresse à Madame Betty Odalo. S'il vous plaît, vous pouvez réagir à cette première question, s'il vous plaît. En espérant que les autres intervenants, en permettant aux autres participants de préparer leurs questions. Madame Betty.
Thank you so much for that question. I hope you can hear me okay. And
yes,
I hope I understood.
You.
Yeah, thank you. And I hope that I understood the question correctly, because the interpretation was a little bit delayed. But I'll attempt to answer anyway. I think the question spoke to what extent can we tackle these problems that I was highlighting. I began by speaking about in my presentation how we understand equality in reproductive health, in how it sets a basis and requires access for reproductive healthcare services without discrimination, and for services to be affordable, accessible, available, and of good quality. And this places an obligation on the state, to ensure that these services are accessed in this way. And if services are accessed in this way, I think we'd be able to address some of the issues that I'm talking about. So for example, when we're speaking about the abuse of women in facilities, and we've worked with governments, including at local level in Kenya, to address some of these. Some of our work has included, apart from highlighting the situations where abuses are meted against women, to work with a government to understand what quality maternal health services should look and feel like for women, that they should be respectful, that they should be access to information. Women should be told what it is to expect. They should be given an opportunity to ask questions and receive the answers to those questions. They should be given enough information in order to decide what treatment, for example, they should get. If it's a woman who might be required by the doctors, for example, to get a cesarean section during delivery, the information should be given to them in order for them to be able to consent to the services, etc. And so some of the actions that we've taken together with governments is to help them to understand what quality, affordable, accessible services look like, and then work with them and their service providers to be able to implement this when they're providing services to women and girls. And so we've worked with service providers who've been able to be trained on respectful maternal health care, for example, and offering care in a respectful way. And that has gone a long way to address some of the issues. There's still a lot of work to be done. This has obviously not been done across the country. And so there's opportunities there, but there's lessons in terms of how it is that this can be implemented. When it comes to access to safe abortion and post-abortion care, it's still the same, to advocate for access to safe abortion care along the lines of, care being respectful. So when women and girls are going to be received in facilities to seek abortion care, they're received in ways that are not intimidating, in ways that are not judgmental, because they're going to seek these services, etc. But also, with regards to safe abortion, there's been a lot of work that has had to be done when it comes to the legal framework. So ensuring that there's certainty amongst service providers on the legality of abortion, on when they can provide abortion, and when they would not be in trouble for providing abortion, has gone a long way to ensure that they are confident enough to provide abortion services to women and girls when they come to facilities. So I guess that the interventions look differently for different services, but the principles that underlie access in a way that's respectful, in a way that ensures that there's no discrimination, in a way that ensures that there's quality and respect, I think remain the same. And it takes engagement with government, it takes training of health service providers, it takes education of women and girls so that they know what their rights are and they can demand them. And it takes a legal and policy environment that is supportive of all this. Thank you very much. I hope I've addressed to some extent that question.
Merci, chers participants et intervenants. Je viens de vous faire part de ce que nous souhaitons recevoir vos questions via le chat, car nous avons accusé un très grand retard et cela signifie que nous ne pourrions pas prendre un maximum de questions. Car nous allons donner la parole au commissaire pour le mot de fin. Mais j'aimerais vous rassurer que vous aurez toutes les réponses à vos différentes questions.
Il y a Madame Danyogo qui veut poser une question.
Je vous remercie.
Merci, professeur Serge,
Professeur,
pour ce débat qui n'a pas pu être très long.
Excusez-moi.
Je ne sais pas,
Madame Danyogo
je parle sous le contrôle de M. Bruno. Je vois un de nos chers participants, M. Makaya Dagno, qui a levé la main. S'il a une question qui est très courte, avec une réponse d'1 minute, on termine avec lui, après je vais clôturer.
Alors.
Mr. Makaya.
Oui, allô, vous m'entendez?
Oui, on vous entend, madame.
D'accord, bonjour, chers tous. Merci aux intervenants pour la qualité de leur intervention. Là, ma question s'adresse à Madame Odalo Betty. Lors de son intervention, elle a fait savoir que au Kenya, la Constitution prévoit l'avortement, si j'ai bien compris, sous réserve, la Constitution prévoit l'avortement, mais d'autres dispositions légales constitueraient un frein à l'ouverture, à la pratique de ce droit. Alors, ma question, c'est de savoir que fait donc la société kenyane ou l'institution des droits de l'homme au Kenya pour soulever l'inconstitutionnalité de ces dispositions qui constituent une entrave à l'avortement. Voilà. Merci.
1 minute, Mrs. Betty.
Thank you very much for that question. I wouldn't be able to speak to a lot of what the human rights institution is doing in this situation. I can only speak to, I know that they're doing a lot, but I can speak to the extent to which the Center for Reproductive Rights has worked with them, including challenging in court the arbitrary application of the penal code provisions that outlaw safe abortion, including in situations where safe abortion is provided in line with the Constitution. And what this has ended up doing is clarifying the position of the Constitution when it comes to abortion vis-a-vis the position of the penal code. And so the courts have clarified, one, that the Constitution came after the penal code. And so for the purposes of provision of abortion, the Constitution would be the law of reference. In situations where abortion is provided in a manner that is contrary to the Constitution, then the penal code does apply. And so there remains situations, where abortion is provided in a manner that is criminal. And only in those cases would the penal code then apply. But as a basis and as a beginning of everything, there's just a distinction between the penal code and the Constitution, and the Constitution is the one that applies first. Even in situations where the penal code is being applied to challenge or to highlight, for example, that a law has been broken in how abortion services have been provided, that has to be still the Constitution that is made reference to, because it's only when abortion services are provided contrary to the Constitution that we will then have the penal code provisions applying. I hope that made sense. So there's been a clarification of the position of the laws.
Je vous remercie, Madame Betty, pour cet éclairage que vous avez donné à notre ami. Je salue parmi nous la présence, même un peu tardive, du président Angaman qui nous a rejoint. Bon, malheureusement, faute de temps, donc l'allocation de Zoom va se terminer. On aurait aimé poursuivre ce débat parce qu'il y avait des questions importantes à avoir avec Madame Sanet. Je la remercie pour son excellent exposé d'ordre juridique, ainsi que Madame Eva. Moi-même, je voulais demander à Madame Eva, concernant la prochaine réunion demain, peut-être de la commission, est-ce que ce qui s'est passé au Maroc, il s'agit d'une question d'usage de la force excessive des forces de police, ou bien est-ce qu'on tombe dans des cas de torture? Quel mécanisme va s'appliquer? Bon, usage excessif de la force, ça c'est certain. Mais est-ce qu'il y a torture? Bon, si Madame Eva peut m'envoyer quelque chose par écrit, j'apprécierais beaucoup. Donc, je vous remercie tous pour ces excellents exposés. Les trois intervenantes ont été excellentes. On aurait aimé les entendre plus. Moi, je suggère que le travail qui a été fait par Madame Eva, par Madame Sanin et par Madame Betty ne soit pas perdu. Donc, ce que je vous recommande, c'est de consigner ce que vous avez fait par écrit, de bien le nettoyer et de nous l'envoyer au secrétariat, à moi-même, et on verra pour une future publication. Donc, prenez votre temps pour nettoyer. Et comme comme le travail qui a été fait par Madame Onaima sur la jurisprudence de l'article 5, il doit être donc finalisé et publié. Donc, vous-même, vous avez fait un premier pas pour ce panel. Donc, peut-être on reprendra certainement, si Dieu nous prête vie dans les prochaines commémorations, cette idée qui fait son chemin d'un bon panel du 26 juin. Ce sera quelque chose qu'on va instituer. Alors, faute de temps, donc, il ne me reste plus qu'à vous remercier tous d'être présents parmi nous, de remercier notre secrétariat, M. Bruno, et nos éminents experts sur lesquels nous comptons toujours, et dans le plaisir de vous revoir bientôt à Tunis ou en Afrique de l'Est ou ailleurs. Portez-vous bien, be safe, see you, ila al-liqa.
Merci. Shukran.
Bye.